Hello, this is for the exam, the insurance exam for property and casualty, and one of the main components of writing up a policy is the elements of a legal contract. So I have a memory hook to try to help memorize for the exam the elements of a legal contract and particularly how that contract applies to property and casualty type of contract. So here you can see I came up with this. Actually, it's a real college. It's called American College Construction Lawyers. So it's the American College of Construction Lawyers. So that struck me as odd, but it was working for the elements of a legal contract. So here is the American flag, right? And it's propped up with these sandbags up holding this crane. This is a crane, and they're constructing the college. See, I put a bell here. It's like learning, ringing the bell. Anyway, these are construction workers. They're actually devils, which is equivalent here. You can see it to lawyers. So you'll see now what that means. So I'll come down, and you can see the American part. The A is the agreement. You can't have a contract if you don't have an agreement between two people on something. So there has to be the offer. A person makes the offer, and there has to be an acceptance, right? So that makes a complete offer. It can mean a complete agreement. Then C here is for consideration. The premium in an insurance contract, the premium paid is consideration. And consideration generally means that the two parties to a contract give an exchange or value to abide by the conditions of a contract. So in this case, it will be payments for premium is the consideration. And then we have construction, where that C is for competent parties. Parties to a contract, they must have legal capacity to enter. It can't be minor. It can't be without your senses. You have to have mentally competent people. And you can't be under duress or drugs or alcohol when you did sign the contract. And then lawyers, the L is for legal purpose. You can't have an enforceable contract that's illegal, that's covering some sort of illegal act. So now for particular types of insurance as it applies, contracts as it applies to insurance, you're going to have the following. See, so here you have characteristics of an insurance contract. So here is a contract of adhesion. So that basically is one party telling the other, like, hey, take it or leave it. This is how it is. And you either buy the insurance that I'm offering, or don't buy it. It's whatever it is. So it's called of adhesion. If there's a doubt or troubles, the court will usually favor the insured. In this case, the one has to take it, right? Because you either take the deal or you don't. And so if there's an issue, they're generally in favor of the insured. Okay, so what I did is I made a little memory thing here. I had this big dude. In this case, this big something or another is the insurer. And he's telling him, take it or leave it, and he puts adhesive tape on his mouth, so you remember, hey, take it or leave it, and that's how I remember that. And then we have aleatory contract. Well, parties of contract exchange on equal amounts. So in effect, we have these two guys on teeter-totters. One guy's name is Al and one's Tory. And in this case, the Al is actually the insured and Tory is the insurer. So you have this guy says, if I move a little bit, you'll pay much by landing hard, right? All he has to do is show a little bit. This guy's going to come a long way down. So in this case, if for relatively small amount of premium, if there becomes a cost that needs to be insured, the Tory is going to pay hard, right? Pay a lot in exchange for just a little premium. So that's how I recall that part. And now we have the personal contract. Well, it's personal in the sense that you can't transfer it to another person unless, something like life insurance, and very few cases that need approving of the insurer in order to assign it to someone else. And they are unilateral contracts. So uni meaning one way, one party is bound contractually. They have an obligation. So the insurer has an obligation to indemnify or to bring any loss to a whole position in the future. So that's something. So only the insurer can be charged with breach of contract. And then you have the conditional. Well, it is a conditional because it's conditioned on one thing happening and followed by the other. So both parties to a contract must perform certain duties and follow rules of conduct to make the contract enforceable. The insurer may pay claims if the insured has complied with the policy conditions. So there you have the whole ball of wax. And thank you for watching.